mindful that indigenous people and their business have an integral role to play. Only through engaging indigenous people and respecting their rights and consent could we build an inclusive economy that benefits us all. With this in mind, I'm pleased to share with you that Taiwan just joined the Indigenous People Economic and Trade Cooperation Arrangement, the IMPECA, becoming a founding member alongside New Zealand, Australia, and Canada. IMPECA is the world's first multilateral arrangement which creates a framework for its members to work with indigenous peoples to strengthen their economic empowerment. Uh, it not only reaffirmed indigenous rights enshrined in the UN Declaration on the Rights of Indigenous People, but also emphasized the importance of free, prior, and informed consent. Based on this, uh, this arrangement seeks to unlock cooperation in areas such as responsible business conduct, protections of traditional knowledge, and create opportunities for micro, small, and medium-sized enterprise. This is just one example of how indigenous rights and inclusive economy growth could be made possible. I'm sure our panelists have a lot more to share, and I look forward to their insights. Once again, thank you all for joining us, and I hope that you will benefit from today's panel discussion. Thank you.
Thank you so much, Ambassador. Much appreciated. And now I would like to turn to Kalivat Gadu, the Deputy Minister, for the keynote speech. He's the Deputy Minister of the Council of Indigenous Peoples, ROC, Taiwan. And please, Sir Deputy Minister, you have the floor.
Thank you, Leah, for your introduction. I would like to greet our Ambassador Lee and all of our ladies and gentlemen. I just greeted everyone in my own language, the Baiwan language. I am Zaliva Gadu from the Baiwan people in Taiwan. I am also the Deputy Minister of Council of Indigenous Peoples. I would like to thank TECO NY for introducing us and for hosting this meeting and giving us this opportunity to share with you our experience in Taiwan in promoting and exercising FPIC. This is my outline. First of all, I will be talking about the FPIC mechanism in Taiwan. Secondly, I will talk about the common developments seen in indigenous areas in Taiwan. Thirdly, I would like to talk about our process of exercising FPIC. Finally, sharing with you a specific case study to see how we establish FPIC in Taiwan. Now, we can see that in 2005, Taiwan legally adopted the United Nations Declaration on the Rights of Indigenous Peoples and incorporated it in our Indigenous Peoples Basic Act. Under the UN Declaration, Article 32, Item 2, states shall consult and cooperate in good faith with Indigenous peoples concerned through their own representative institutions in order to obtain their FPIC prior to the approval of any project affecting their lands or territories and so on. Therefore, in our Indigenous Peoples Basic Act, we have our own article corresponding in the Article 21, Item 1, which relates to FPIC. Now,
so what is free, prior, and informed consent? And this mechanism is aimed to protect their land developments and their resources rights. Therefore, in the Article 21 of Indigenous Peoples Basic Act, it emphasized that when governments or private parties engage in land developments, resource utilizations, ecology observations, and academic research on indigenous land or indigenous villages, they shall consult and obtain a consent or participation of indigenous people or indigenous villages. Therefore, for public and private sector, when they are using indigenous lands or indigenous villages for land developments, they should have a consult and consent process. These are some of the common developments happening in indigenous areas. You can see on the slide, it includes road constructions, hotel constructions, minerals, rock and soil related facility constructions, and for example, like for renewable energies like solar and thermal developments or funeral related facilities, and even for the storage facilities for hazardous material. There's also mining of natural resources, including rock, soil, and minerals. There's also use of surface and underground water resources, or there are reservoir works for water storage, or there are large-scale drainage and sewage treatment systems. These are very common in indigenous areas in Taiwan. So how do we exercise FPIC in order to ensure that they have the indigenous communities' autonomy? So far in Taiwan, legally, and our council have established and legalized 746 indigenous communities. When there are incidents or events happenings or land developments that happens in the indigenous lands or indigenous villages, they need to have indigenous community assembly. As I mentioned before, when they are doing land developments, ecological conservations, or academic research, they need to have indigenous community assembly. So on the assembly day, they need to have over 50% attendance at the assembly. And during the assembly, they need a majority vote from the attending household, and that leads to approval. If the incidents involve several indigenous communities, they need to have majority of indigenous communities involved to approve this process. Otherwise, they will not be able to develop the land. So this is how we exercise FPIC. Let me give you an exact case studies in Taiwan to show us how we implement FPIC in Taiwan. Asian cement corporations started to develop these areas in 1973 or 49 years ago. They rent this place from the governments in Taiwan that belong to the Turko people in Hualien, and that's started to mine cement and export worldwide. After a documentary in Taiwan called Beyond Beauty, Taiwan from Above, many people are aware how large this cement company's development is. And you can see on the left-hand side on the photos that's how groundbreaking and also how astonishing this area is. And that's mostly because of the documentaries by Chi Bolin called Beyond Beauty, Taiwan from Above, that many people in Taiwan are aware of the land destructions by Asian Siemens corporations. And that's why this case become a highly contentious and also highly debated cases in Taiwan, including our President Tsai Ing-wen, pay special attention to this case as well. As I mentioned before, that ACC, this cement company, have started to develop this area since 1973. So they have extended their mining rights twice in 1978 and 1987. At that time, the local government did not explain to the local indigenous people regarding to the land rights and the land ownership. And in the past, we didn't implement the FPIC, so the local government directly leased the land to ACC, and therefore the indigenous people cannot use their traditional lands as well as have the traditional ownership. Therefore, in 1996, Turko people organized support groups and initiate many protests. As you can see on the slide, these are the two appeals from Turko people. First of all, they hope ACC can cease the leasing of indigenous reserve lands. They will also want to have restitutions of indigenous ownership of the land. Due to many protests in this case, if you can see from the next slide, in 2017, in March, the Ministry of Economic Affairs extended for the first time of their mining rights for 20 years, all the way until November 2037, and that triggers a lot of anger in Turco people, especially the local indigenous people have been emphasizing that their traditional lands have been exploited. They do not have the rights and the opportunities to stay and live on their traditional lands. So on June 25th, 2017, they marched in front of the central government executive yuan and also to protest many times at the ACC shareholders meetings. They also filed a case to the Supreme Administrative Court in 2017 and hope that they can revoke the extension of the mining rights. After 4 years of legal process, the Supreme Administrative Court found that FPIC was not practiced prior to the extension of mining rights. Therefore, on September 16, 2021, they dismissed the ACC appeal and revoked the extensions of mining rights by Ministry of Economic Affairs. Regarding to the investigation group, on December 18th, 2017, and actually the Turco representative proposed to revoke the extension of mining rights to ensure they can implement the Indigenous People Basic Act. They also urged that ACC to participate in negotiations to resolve the dispute. In order to settle down this long-term dispute, in 2018, on March 29th, which is also the fifth Indigenous Justice Committee's meetings, the President Tsai instructed to have a fact-finding task force comprising members of the indigenous community, governments, and ACC. And the central government also decided to convene this task force in the same years on June 20. After 4 years, you can see the investigation result, and they found that there is a flaw in the administrative operation of indigenous reserve land lease. They also neglect the customs of traditional land use of Turco people. However, in the ACC leasing process of these lands, they so far had not found any evidence to prove the infringement. However, due to the concerns of British people, they decided to rely on the legal process to investigate and settle down the case. In the follow-up, on February 9th this year, the central government have announced and published the results and the report. They also have 4 additional resolutions in the report, and they request that ACC should implement the FPIC with indigenous people. In the future, all the relevant governments and private sectors will continue to promote the additional resolution or suggested items. According to the report and resolutions, as well as consensus from different parties, they decided to have an assembly convened on February 12, 2022 to vote on the case. And we also provide necessary support to the assembly. On the day, there are 375 households attended and 294 families decided to support the case. So 78% of the attending household agrees for ACC to continue mining on this area. We respect their autonomy and the results. this is what we have implemented in Taiwan based on the indigenous rights and the FPIC. We hope that everyone can respect for indigenous rights in prior to achieve shared existence and prosperity among ethnicity. That concludes my presentation. Thank you.
Well, thank you very much, Deputy Minister, for that very fascinating case study regarding the implementation of FPIC in Taiwan. And I would also like to thank you for sharing your language with us. When I started by sharing my language, I introduced myself in my mother tongue. And I live and work in the traditional and shared traditional territories of the Musqueam, Squamish, and Tsleil-Waututh peoples in what is now known as British Columbia. But I'm coming to you tonight from the territories of the Lenape people here in New York City. And when I introduced myself in my language, I told you that I'm a member of the Wolastoqey people. We are the people of the beautiful river, which is the St. John River in Quebec, New Brunswick, and Maine in the United States. And this means so much more to us than the English term that is used to describe us, which is Maliseet. So as Indigenous peoples, we are literally defined by our territory, by our beautiful river. And this is how important our traditional lands and waters are to us. And as such, the reason why FPIC is just so very important. So now we are going to move into the panel portion of this discussion. And I am delighted to be joined today by such an illustrious group of speakers. We have about 70 minutes, maybe a little bit less, for the discussion. And I plan to briefly introduce each speaker before I invite them to speak. I'll ask them to speak for 7 to 8 minutes about their work related to the theme of this 21st session of the United Nations Permanent Forum on Indigenous Issues. And this will be followed by a 30-minute discussion where each panelist will be invited to provide a 3-minute response to 2 very important questions, which I'll share when we get to that point. So let's get started. First, we are going to hear from Christina Stanton. She is the Director of Operations at First Peoples Worldwide, and she has, in her law experience, has exclusively focused on public housing and tribally designated housing entities and some local public housing authorities. She practiced in both tribal and state court and was engaged in policy work, contracting, employment, construction, landlord-tenant, and federal Indian law. You have the floor, Christina.
Thank you so much. Good evening, good morning, good afternoon, wherever you're joining from. As I mentioned, I'm the Director of Operations at First Peoples Worldwide and come to you today from the unceded lands of the Cheyenne, Ute, and Arapaho peoples, otherwise known as Denver, Colorado. At First Peoples Worldwide, we sit at the intersection of business, law, and finance to forward Indigenous rights. It is that perspective that I will share with you today. I appear on behalf of Kate Finn, our Executive Director, who is the 3rd Indigenous woman to lead our organization. And I am so honored to be here in conversation with all of you. We've seen an immense harnessing of knowledge and strength to advance Indigenous rights to protect their lands, resources, and people. But there is so much to be done in the way of building capacity for states, businesses, and investors to better respect and support Indigenous economic development and self-determination. Indigenous peoples are still here, and as key rights bearers impacted by many business operations, their rights should not merely be considered, but should be centered. Today, I will talk about some key observations that we have made at First Peoples Worldwide and some best practices to carry forward in our shared work alongside Indigenous leaders. First, I want to discuss briefly the immense opportunity available in Indigenous economies. It is key to recognize the persistent and systemic barrier of economic invisibility that impacts Indigenous peoples. And yet, we know that Indigenous power is ascendant. Tribal sovereignty and increased self-governance has created new economic and employment opportunities for Native nations, resulting in economic growth and improved well-being. Self-determination means that an Indigenous economy can flourish in such a way that upholds human rights and is no longer extractive and harmful, but instead additive to communities. As Cherokee economist and our founder, Rebecca Adamson, defined in the 1990s, Indigenous economics is the science of production, distribution, and consumption according to millennial-old principles of balance and harmony. We can see many examples of Indigenous-driven economies today in North America. Since 1997, Native female-owned businesses have grown by 201%, at almost twice the rate of growth for all female-owned businesses. And in North America, Indigenous-led capital and investment projects have created great opportunity for Indigenous entrepreneurs and businesses. For example, the organization Native Women Lead is seeding a major capital fund to bring more Indigenous women into financial support spaces and to create additional opportunities for those who have traditionally not been able to access the market. In Canada, Raven Indigenous Capital Partners has an impact investment fund that's been launched in response to the resource gap faced by many Indigenous entrepreneurs, and it implements a very unique Indigenous impact screen to award investments. And so instead of following the age-old and unaligned extractive models of deals in the past, these examples show that capital and investment funds can be value-aligned and promote true Indigenous self-determination. As economic opportunity grows, Indigenous economic power must be built in a rights-based way to influence the capital markets towards the rights of Indigenous peoples. I'll now turn to the ways in which we can apply a rights-based framework to move the markets to better center Indigenous rights. We look to the UN Declaration on the Rights of Indigenous Peoples as a framework for direct engagement, deal-making, and negotiation. The Declaration must be viewed as the most important international legal framework through which Indigenous communities relate to outside investors and businesses. Specifically, we believe that the right to free, prior, and informed consent, or FPIC, is the centerpiece of best business practices. Often, Indigenous business owners seeking capital through investors will lose autonomy over business decisions. For a business deal to truly respect Indigenous people's right to FPIC, it would need to ensure the retention of their autonomous governance over and participatory rights in business decisions and outcomes. As FPIC models an iterative process that occurs throughout a project, so should Indigenous rights be incorporated at every level of deal-making and negotiation. Human rights should be a key consideration at all points along the supply chain, including procurement. By using the Declaration to guide rights-centered language in project conception and deal-making, we can not only spur new and better deals for Indigenous economies, but we can also make the business case for corporations that upholding Indigenous rights is critical to their success too. We know that there are significant operational costs and reputational risks that companies face when operating on Indigenous lands without their consent. We also know that social license to operate, or whether or not a local community will accept a local project, is the #1 risk consideration for mining companies across the globe right now. And for Indigenous peoples, this necessarily includes FPIC. Social impact assessments and human rights due diligence, therefore, are a way for a corporation to identify and evaluate social impacts and therefore social risks to a project. Fulsome due diligence not only exposes the risks to a project and its potential success, but it also highlights the potential harms to Indigenous peoples, their lands, and resources. Properly implemented, due diligence will consider whether FPIC has been obtained in conformity with the Declaration. We also know that a lack of adequate human rights protections can have adverse material impacts. At First Peoples Worldwide, we tested this proposition by conducting a case study on the costs associated with the significant social conflict that occurred from the Dakota Access Pipeline, which proceeded without the consent of several impacted tribes. Our study showed that while the pipeline was projected to cost $3.8 billion at the start, the case study estimated that the costs incurred by Energy Transfer Partners and other DAPL-related firms were not less than $7.5 billion. Thus, there was a direct correlation between the failure of the companies to respect the rights of Indigenous peoples and the social conflict that was generated from that failure, which all resulted in significant material loss. I must also acknowledge that these material losses for a corporation reflect the very real harm to Indigenous peoples. We know that Indigenous peoples are increasingly subjected to violence when standing up for their rights to their lands. So how then do we walk alongside Indigenous leaders to move the needle on market and state behavior to better address Indigenous rights like FPIC? We can continue to center rights-based language and make the business case for corporations to integrate Indigenous rights at all levels of operation. Creating a direct line of communication about the types of development sought on Indigenous lands gives Indigenous leaders the opportunity to negotiate and to implement their own development priorities. Indigenous peoples and allies can push corporations to engage with them at the earliest stage to create a foundation of cooperation and mutual understanding. Corporations should integrate rights-based processes in order to avoid the material risks that are caused by violating human rights. Around the globe, Indigenous peoples are building capacity to engage with capital markets and develop their own economies in a way that's consonant with their values. Indigenous peoples' expression of self-determination has led to beneficial partnerships and sustainable development and portrays a very powerful representation of economic and Indigenous sovereignty. Business and state solutions need to respect Indigenous peoples or have strong Indigenous partnerships to ensure respect for Indigenous lands, cultures, and societies, along with our shared environment. At First Peoples Worldwide, our executive director has said that Indigenous solutions know no borders. And I believe that is how we must step into this next phase of partnership. Thank you.
Well, thank you so much, Christina, for sharing these best practices. I agree with you that Indigenous power is indeed ascendant. And so next we are going to move to Darrell Kalika. Darrell is the director of the Institute for Tribal Government at the Portland State University and has over 20 years of experience as a legislative, policy, planning, and regulatory advisor with the U.S. Attorney's Office, District of Oregon, the U.S. Army Corps of Engineers, intertribal organizations, and various Indian tribes. You have the floor, Darrell.
Thank you, Leah. So, Niach Maiski, Niach Lawit, Niach Patwai, Inas Wanisha, Tuchamshish. So in my language also, good morning, good evening, good afternoon, good day. My traditional name is Tuchamshish. My other name on my documents from the state of Oregon, United States, my name is Darrell Kalika. I am the director of the Institute for Tribal Government. I'm also a citizen of the Confederated Tribes of Warm Springs, which is located here in the Pacific Northwest, which is where I'm joining you from at the confluence of Nichiwana, the Big River, and the Willamette River here in Portland, which many of the confluences of rivers are also centers of commerce and trade that were inherent and indigenous to all of us as people. So it's an honor to be here, but also it's an honor to present to you from Portland State, or from Portland actually, and talk with you a little bit about what it is that we do at the Institute for Tribal Government, which was established 22 years ago by late Congresswoman Elizabeth Furs and the late Roy Samsel, who was a undersecretary in the Department of Interior. And so what we do is essentially work with tribes, tribal leaders to help support their efforts as government leaders and statesmen and women in various forums, particularly here in the US with regard to the federal and tribal trust relationship, but also in addition to that, working with their state counterparts and internationally. So one of those things that we also engage in is supporting what tribes are doing on those sort of cutting edge areas of governance, but also at the base, which is helping new tribal leaders acclimate to their duties and roles in their leadership capacity. And so much of that has really over the years been a process of helping tribes understand that collaborative space and collaborative governance around opportunities, especially new and emerging opportunities that intersect with tribal resources and lands, especially things related to infrastructure and utility. And more recently, really looking at the intersection of all of these things with our water resources. Because for many of us, if not all of us, water is a significant underlier in our cultures, our spirituality, our overall health, and so forth. And so we're really looking at how that intersects with many things. But for us in the Pacific Northwest, water sits at the heart of our cultures, our spirituality. When we set the table for our ceremonial foods, the first food that's set is water. And so much can't exist without that, and not just us as human beings, but for all in creation, those are really considerable resources. But over time, with the work that we've been doing with tribal leaders, one thing that we've consistently heard from tribal leaders is that we want to ensure that our tribal partners or partners we engage with, whether that's government sector at the federal level, at the local and state level, internationally, as well as with various other sectors, whether that's the private sector, utilities and infrastructure, academia, philanthropy, and so forth, that we want to ensure that our partners understand how to engage. So one of the programs that we have at the Institute for Tribal Government is a certificate in tribal relations, which really was started because and at the recommendation of the tribes that we work with. We have a national policy board, which exists of tribal leaders from across the United States, the lower 48 and into Alaska. And we receive quite a bit of advice from them on how we'd like to shape our curriculum with regard to engaging. Primarily, we started out our programming around working with the federal government and federal agencies, but that expanded and we acquired interest from state governments, local governments, and now increasingly in the past 3 years especially, growing interest by the private sector and nonprofits and NGOs and the philanthropic world to better understand how to engage with tribal communities. So, for example, in the United States, we have a lot of compulsory and statutory requirements around how to engage and consult with tribes, everything from the National Historic Preservation Act to the Clean Water Act, the Native American Graves and Repatriation Act. Provide guidance when there's a federal or state interstate nexus. But where we're running into features is how the private sector and those that aren't bound by those compulsory consultation requirements, how do they best engage and work with tribes? So part of our programming has been to help really kind of get into those key details of how to integrate free, prior, and informed consent in practice, and creating these communities of practice for organizations in all of those sort of diverse disciplinary sectors with regard to thinking about how do you do that? How do you engage a community? How are relationships actually built? Community by community, and we have identified the fact that each Indigenous community has its own unique set of features, cultures, dynamics that are inherent to those people and those lands, and acknowledging that much of that is a stewardship relationship, and how do we best honor that? And it's really a shift in paradigm for those organizations and sectors of industry that are engaging in this work. I think that they realize that this is not easy, that this is an investment over the long haul, that this may be intergenerational work. And so sort of wrapping up where it is in our programming that we kind of serve that place is in helping folks understand those really critical and valuable resources that we all share in common as human beings, but also with all other things in the world and in creation. And so, with regard to that, we are looking at sort of things and opportunities, mechanisms that help support intergovernmental affairs, the intersection of all of these other different sectors. And then I think the other thing that's been a benefit are forums such as these to not only learn and hear about what folks are doing in the US and in North America, but to hear and learn from examples and success stories that come from around the globe and around the world. So this is really kind of at the Institute for Tribal Government, because we are also an internationally facing university as well, that we look at some of those best practices. So I just, again, thank you for the opportunity to share about the work we do, and especially later to talk a little bit about the work we do around protecting water, because I think that's something all of us share in common.
Well, thank you so much for that. And Darrell, I really appreciate your reminder of the importance of water to all of our cultures and to every human being, frankly. But, that certainly resonates with me, given the importance of our river. And so I appreciate it very much. So now we are going to hear from Professor Pablo Ruida Saiz, the Associate Professor at the School of Law at the University of Miami. His primary interests include international and comparative constitutional law, law and society, social movements, armed conflict, and globalization. Among other things, he worked as a deputy justice at the Colombian Constitutional Court and was a legal advisor to the Colombian presidency. You have the floor, Professor.
Thank you very much. Okay, good evening, good morning, and good afternoon to everybody. First of all, I'd like to thank the Taipei Economic and Cultural Office in New York for the invitation, and Leah for moderating. I am talking to you from the lands of the Seminole and Miccosukee peoples in what is now Miami, Florida. In the following 7 or 8 minutes, I will talk about the comparative empirical analysis of prior informed consultations in Latin America pursuant to the International Labor Organization 169 Indigenous and Tribal Peoples Convention. In other words, I will address the ways in which Latin American countries have implemented the obligation to consult indigenous peoples. So if you look at the ratifications of this convention, there were 24 ratifications of the 186 different states that could possibly have ratified, 2/3 of which are in Latin America. So there is a convergence with respect to the states that ratified the convention. And given the fact that Latin American countries share similar legal systems, relatively similar political systems as well, with strong presidential systems, similar economies that are reliant on commodities and extractive industry, and they have comparable colonial histories and similar histories of exclusion of indigenous peoples and other ethnic minorities, one would expect a significant degree of convergence with respect to the reception of the convention and very similar ways of dealing with prior consultations. However, the trajectories could not be more different, and one can learn a great deal from these differences. They're different in multiple ways. The first issue is who is protected. For example, in Peru, Amazonian indigenous peoples were protected initially, but Andean indigenous peoples were only protected afterwards and not without a significant struggle on their part. In Chile, on the other hand, consultations are limited to indigenous peoples. In Mexico, they include both indigenous peoples and Mexican communities of African descent, Afro-Mexican communities. In Colombia, they include indigenous peoples, Afro-Colombian communities, and Roma communities as well. Now, they also differ with respect to the mechanisms of protection. And here, courts have played a more or less important role in Colombia, Chile, and Mexico, and to some extent in Peru as well. On the other hand, administrative mechanisms have played a more important role in other states, including Peru to some extent, which does not mean that litigation is completely out of the picture. However, it's comparatively less important or has played a less important role. Now, they also differ with respect to the forms of interaction. So, for example, you have interaction between indigenous peoples and governmental agencies in Peru, Mexico, Guatemala, Honduras to some extent, and Bolivia. Whereas in Colombia, you have direct interaction, of course, mediated by the government between indigenous peoples and multinational corporations or any kind of corporations. They also differ significantly with respect to the intensity of the protections awarded. So in places like Argentina, Bolivia, Colombia, and Mexico, consultations are regarded as fundamental constitutional rights. And here, an important aspect is that this convention actually made several Latin American countries reform their constitutions to include the right to prior consultations. In other states, however, like Peru or Guatemala, the protection is statutory. In some states, like Bolivia, Mexico, and Colombia, you see that Prior consultations include free, prior, and informed consent under certain circumstances. And here there is some convergence between these three countries. And this convergence is based on two factors. First, the intervention of the Special Rapporteur of the United Nations. And secondly, the importance given to the decisions of the Inter-American Court of Human Rights. Now, these countries also differ with respect to the extension of the protection. Most countries have adopted the Peruvian model, which provides the need for consultation of all legislative and administrative measures, with Colombia being sort of an outlier that includes the obligation to consult also constitutional amendments and the economic or infrastructure projects in themselves, meaning that it's not only the administrative measure that is consulted, but also the projects in itself that is consulted. And that is why indigenous peoples interact directly with the companies or organizations that are going to execute those projects. Now, in consultations with respect to governmental bodies, these governmental bodies play a very different role. So, for example, in the Peruvian model again, the body that regulates the consultation, the Ministry of Culture, does not direct the process of consultation at all. Rather, it is the agency that wishes to promote a specific project or a rule, that which carries out the process directly with the affected groups or peoples. In the Colombian model, on the other hand, it is the Ministry of the Interior that directs the process, regardless of whether the purpose of the consultation is a project or a rule. There are other models that include the Ministry of Culture, as well as the Ministry of the Environment, like the case of Chile. Now, what explains these differences? Let's look at some of the factors. And here I want to highlight two basic factors. One, which is political, and the other one I call socio-legal. The political factor has to do with the degree and form of political incorporation of indigenous and tribal peoples into the political process proper. The socio-legal aspect has to do with the role of courts, and especially the extent to which indigenous organizations engage in public interest litigation. And there also the recognition of indigenous rights, especially the right to land. So when we see very strong recognition of the right to land, we also tend to see stronger exercise of the right of prior consultation. Now, we're also able to exclude other factors. For example, one factor that was sort of a candidate to explain the differences was the distribution of indigenous communities in the territory, in the sense that greater concentration would mean more activism and a stronger right to consultation, but that is not shown to be the case. Other social factors as ethnic or demographic, for example, would tell us that states with greater indigenous populations like Bolivia, Ecuador, or Guatemala would have greater or more stronger consultation mechanisms. However, they do not. And on the other hand, Chile and Colombia that have much smaller indigenous population have stronger consultation procedures. However, the strength of indigenous organizations, not the number of participants, but the effectiveness of the legal tactics that they use and the legal capital that they have, seems to explain a great deal of the strength of consultation procedures. Now, what we see here in the end, let's talk a little bit about the mechanisms or processes through which consultation came to be or become important in some countries and not in others. What we see here are two is the interplay of two different mechanisms or processes. One is international, and the other one is domestic. Internationally, we see that state actors do allow the diffusion of ideas and parameters from one country to another, but it's not through complete imitation of one another. It's more like let's other countries try whatever policies they want, and we can learn from their experience and adopt the measures that we want and not those that we don't want. And as I said, to the extent that there is convergence, it has to do with the role of the United Nations Rapporteur and the role of international organizations, especially the Inter-American Court of Human Rights. Domestically, we see that indigenous mobilizations matter significantly, and the strategies used by indigenous movements affect the level of control that they have over the whole process. Specifically, legal mobilization has affected significantly affected the development of the right to prior and informed consultations and consent, expanding it to include prior consent in some countries and not in others. The access to the judiciary and having the necessary resources to pursue litigation are two of the main factors that explain the development of the right to prior consultations in Latin America. So, in the end, and to finish with this, one important aspect to consider is that domestic litigation is not enough. Both international and transnational litigation, for example, using the Alien Tort Statute in the US federal judiciary, have been instrumental to strengthen the rights of indigenous peoples. And with that, I would end. Thank you.
Well, thank you very much, Professor, for this comparative analysis. It's very interesting to hear the differences regarding the application of the convention. I'm not sure how long this research took, but it seems very, very comprehensive. And so next, I am very pleased to introduce Dr. Joseph Scott Gladstone, the scholarly assistant professor at the Carson College of Business at Washington State University. You have the floor, Dr. Gladstone.
Thank you. Oki, Nisto, Joe Gladstone, Nisto, Kinimi. I am speaking to you from the Coast Salish country up here in Puget Sound. My work focuses on business education, primarily Native and Indigenous people. The work that me and my partners look at is grounded in exploring strategies for developing Indigenous economic sovereignty, primarily in the area of business education. The work that we do fits with the UN Declaration on the Rights of Indigenous People because, you know, we're looking for similar universal frameworks that fit within the minimum standards for the survival, dignity, and well-being of the indigenous peoples of the world. We follow, actually, the UN principles for responsible management education, which is also known as PRIME, and for the roles of sovereignty primarily. We explore, you know, who generates the knowledge for indigenous people, who has permission to explore, question the wisdom that indigenous people have, and then how is this knowledge used, all within the context of management education. Challenges that indigenous people have had over the years, primarily at the colonization, is a form of colonized knowledge, colonized wisdom, where we understand that there are people who want to improve their health and well-being and their economic sovereignty through their own lens, through their own understanding of the world. So me and my colleagues, we look at how do we translate useful information that can be taken from the West and transform it into a way that it's useful for Native and Indigenous people. We are looking right now specifically at the challenges that Western style education has with Native and Indigenous people. I'm with a partnership here in the United States and in Canada, New Zealand, and Australia. And we're looking at this from our own perspective, our own lenses, and looking at ways to consolidate our knowledge to find these common grounds. My work follows the principles, the 6 principles of the responsible management education, which is the purpose, the values, the method, the research, partnerships, and dialogue. And for the purpose that we look at for the education is communities, the Native and Indigenous communities that want to grow their economies, to make their communities better, but to do so within their own cultural values, their own understandings, their own responsibilities, and where they see business serving within their communities. That principle also works in with principle 2 of values. What is important? Why does business exist? Are we in it for profit? Are we in it to make the world better? And we're working to understand what these values are. Methods is very important, because when you have autonomy, you get to choose how you will be explored, how go back to my earlier part about who gets to ask the questions, who generates the knowledge. So we look at Indigenous methodologies, Indigenous wisdom, Indigenous knowledge, Indigenous ways of knowing to guide the work that we do so that we're respectful of the community and their knowledge, but also how to use their own knowledge. And that works directly into principle number 4, the research methods, and that we're looking at research is not done to Indigenous people, it is done by Indigenous people, for Indigenous people. So this work is done in partnership with the communities, and we see ourselves as scholars, primarily advisors to these communities that want to know more about improving their well-being. That then works in naturally with principle number 5 of partnership, that again, we are partners with the communities that we work with. We don't come in with our own ideas. We work with the communities and help them discover their own ideas. And all of this is related to principle number 6, which is dialogue. The challenge about generating Indigenous wisdom is being able to both the researchers and the communities about how do we define our work? How do we explore what we're looking at? Again, back to the basic questions, who generates the knowledge and who has permission to ask these questions? And then especially for a lot of Indigenous communities, how is this knowledge used? Will it be used by the communities? Will it be used by outsiders? If the knowledge is used by the outsiders, will it be recognized as Indigenous knowledge? That is something generated from Indigenous communities to a broader world, as something that the outer world has taken and not recognition to Indigenous communities. So that's what we're looking at as a business scholar primarily in terms of Indigenous economic sovereignty, is helping the learn how to do management and business on their own terms and in their own way. Thank you.
Well, thank you very much, Dr. Gladstone, and reminding us of the importance of using Indigenous cultural values to improve the lives of community members is, of course, very, very important. But I also like the way that you flipped the question, talking about translating useful info from the West and transforming it in a way that is useful for Indigenous peoples. We often hear that framed in the reverse, about how Indigenous knowledge can support the West. So very, very fascinating. Now, we are meant to have 30 minutes for the questions. I think we're running just a little bit late. So we'll see how far along we get. And what I would like to do is start with the first question. So what best practices would you like to highlight for businesses to obtain the free, prior, and informed consent of Indigenous peoples in business decisions and outcomes affecting them? And I am going to ask Kalivat Gadu to start us off with the response to this question.
Thank you, Leah, for the question. I think from my previous presentation in the latter part where we shared on our case study on the ACC, Asia Cement Company, basically that is the answer to your question, because we want to have a comprehensive communication and negotiation with the local community for them to understand the economic benefit and also the challenges that they may face for them to decide. So in this ACC case, from the company took 1 year to apply for FPIC, which means that it took them over a year and over 50 meetings convened with the local community to really clear all of their doubts and to share with them the proper benefits. That's how they were approved.
Thank you very much. And I'll go back to Dr. Gladstone next.
That's a interesting question actually to ask. It's, we're looking at economic sovereignty and rights, and everything kind of grounds on wisdom. Each business, you're teaching people how to think strategically, how to grow a business and how to make it successful. My area specifically is in management, focus in management 4 general areas, which is plan, to organize, lead, and control. So the work that I specifically look at is, how do we do these steps? How do we plan in a indigenous way to respect everything that we touch, to draw on indigenous spirituality, which informs all of my work. This idea of transplanar wisdom, which is understanding everything is alive, everything is animate, or it's everything is alive. Everything we do has impact on something else. Or when you're doing any kind of planning or organizing of any kind of activity, you always have to think about what kind of impact you're doing on the environment, what kind of impact you're doing on people. So when you're looking at informed consent, not only are you consenting for research on yourself, you're also giving consent on research to be done. So it makes the indigenous business research, makes it very interesting.
Okay, thank you very much. Professor Ruida Saiz.
Okay, I think, can you hear me?
Yes, we can.
I lost you there for a second. So I think one of the first issues is that the state has a role, and I think multinational corporations or corporations in general also have a role and a responsibility. And that responsibility should be demanded not only throughout the processes of consultation and to the extent that consent is obtained, but also subsequently as well, with respect to the agreements that are attained by the different parties. And enforcement mechanisms, I think, should be swift and should be effective of those agreements. So that means that the whole idea of leaving basically compliance with those agreements to the companies, to the corporations, from my perspective, doesn't really make sense. Doesn't really make sense because I think the state does have a role to play.
Thank you so much. Next, we're going to move to Durrell.
Thank you. Pardon the delay there. I think in terms of considering best practices and again, kind of going back to the space that we work in at the Institute for Tribal Government is really in that notion of originally collaborative governance, but that, you know, expanding out to just sort of a collaborative efforts with whomever those engagements take place with. And I think really sort of imparting on especially non-tribal partners or collaborators, the sort of worldview and values that once you enter into sort of that indigenous framework of doing business or engagement or whatever that may be, that they are relationship building, that they are relationship based. It goes much deeper than just isolated transactions. And so, and part of that relationship building also creates a sense of shared memory. And that shared memory also adds to sort of that invitation of being a part of the community. So if it is, we're looking at things like economic development, it's not just merely putting in a utility scale solar array, that there's a deeply inherent sense of community and relationship about what does that solar array mean to a community. Well, it's providing power, it's providing jobs, it's providing capacity, but it's also providing a nexus between sort of contemporary needs and sustainability and a way in which tribes in their relationship to all these different things and indigenous people relate to things. So I think in terms of best practices that that's one thing if I can impart on people that much of this is really around building those common relationships and sense of collaboration and collaborative spaces.
Excellent, thank you. And Christina, I know that you've already shared a number of best practices. Are there any you'd like to highlight or maybe further expand upon?
Sure. So as I mentioned, we definitely view FPIC as an iterative process, and we want to see it occur throughout the life of a project. So when we think about FPIC and articulations of Indigenous rights, we want to see them throughout all of a business's policies. So instead of being siloed in an Indigenous peoples policy or a human rights policy that applies in limited circumstances, the best practice we would like to see is where corporate policies require FPIC from all suppliers and subcontractors, for example, or when due diligence standards explicitly reference Indigenous peoples instead of a more vague assertion of human rights. And we know also that corporations that do have Indigenous peoples policies will instead choose to adopt less stringent standards of consultation. So they'll decide that they're only going to adhere to consultation, or if they are adhering to FPIC, it will be in certain circumstances. And it might be when they deem that Indigenous peoples are affected negatively. But that is then up to the corporation to determine instead of the Indigenous peoples themselves articulating their rights in the circumstance. And we don't believe that's in the spirit of the declaration. And so we would like businesses to rely on internal practices across the board that implement FPIC, that implement human rights standards that specifically reference Indigenous peoples, and builds that long-term relationship that's inclusive of an Indigenous peoples that's affected by a project from the beginning to the very end stage. And by doing so, it will show that Indigenous peoples, they're not merely stakeholders, they're rights bearers, and they need to be considered, again, from the very beginning to the very end, and seek benefit from developments that are occurring on and near their lands and resources.
Thank you so much. Couldn't agree more. Now, we're going to move to the second question, which is, in your view, what are the most important actions for states to take to ensure the promotion and protection of the rights of Indigenous peoples? And here I'm going to start with Professor Ruida Saiz.
I think that there are two, in my view. The first one is guaranteeing access to the courts to demand the rights, first of all. Secondly, guaranteeing the resources that are necessary to have access, effective access to the courts. So that, in that respect. Also, I think the extent to which states actually provide strong protections for territorial rights. I think is very important. And by territorial rights, I do not just mean the right to the land itself, but a more complex system of rights that include autonomy, that include the right to self-government, that include the right to education, and so on. I think those have shown to have a very strong correlation with the ability of certain peoples, of certain indigenous peoples, to protect their other rights, the right to consultation and the right to consent as well.
Thank you so much. Durrell, what would you say about this?
So, kind of stepping into, and I'm sure other attorneys in the US would appreciate this. When we look at the education of people in the US through our public school system, the absence of understanding the first people's history of this land is missing. But even going into professional degrees like into law school or a master's public policy or what have you, but my experience in law school, we maybe spoke of federal Indian law and tribal people's rights once, and that was in civil procedure my first year for maybe about 3 to 5 minutes. And so just that lack of comprehensive understanding about these inherent rights, which in the US are fundamentally underscored in the United States Constitution in various sections. And so in the US Constitution, the sort of the language is federal, state, and often missing is tribes. And it's right there in our US Constitution, but often is missing in language, whether it's federal language regarding statutes, whether it's oftentimes guidance and guidelines and policies within specific agencies. In the 50 states, it's often missing. The notion of intergovernmental affairs between Indigenous people is a relatively new advent. We're seeing some states in the US do it better than others, but they still have a long way to go. And I think just even that then mention that, I think it may have already been mentioned that we're not merely stakeholders in many interests and in instances, but looking at that particular education process needs to come from the top down, and we're starting to see that better from the White House on down, but it's still, there's a lot of room for improvement in the way in which that occurs. Right, in terms of looking at new legislation, it's still problematic where there isn't a good fit for where tribes and Indigenous people fit in legislation. We often are sort of an afterthought when significant legislation gets passed, and once it starts to get implemented, it's where do we fit? How do we fit Indigenous nations and tribal nations into that? Do we treat them like states? Do we not treat them? And it's really challenging for tribal governments in the US to try to implement programs, access funds, and other things when the actual laws were really never written for us and that we were an afterthought. And we still are. I mean, current legislation regarding infrastructure, we see that it's challenging. The COVID funding that came down from Congress to tribes is rigorous, and we're talking tribal governments. Some are large and have capacity to handle it, but several of them are very small, and it's so rigorous that it's just a challenge. I think so. With regard to thinking about that, I think is definitely acknowledging the evolution of Indigenous people's rights in the US, but also the fundamental federal Indian tribal law and the tribal trust responsibility, I don't think is fully understood by most Americans, but I definitely fear that it's not well understood by our members of Congress and folks in senior leadership in the country. So.
Thank you so much. Now I'm going to go to Kalivat Gadu.
好，谢谢哈。
Thank you. Thank you for the question. This is a huge question, of course. I think, of course, that's for different countries because they have different context and historical developments. They have different answers. In Taiwan, the predicaments of indigenous people is influence of the histories over the past 400 years. We've been governed and colonized by different regimes over the years. So first of all, we need to understand and unveil the truth of historic events and to understand how colonizer exploited indigenous people. We have to have the truth and have the fact in order to find a way for the state and the indigenous people to come to make a consensus. For example, a few years ago, in 2016, President Tsai Ing-wen represents the government to apologize to the indigenous people, and we also have the Indigenous Justice Commissions in the central government, and they have a lot of fast-checking and fact-finding task forces that help to find a lot of truth, and that's how we can have shared prosperity and consensus in the long term.
Thank you very much. Christina, how would you answer this question?
I believe that it's critical that Indigenous peoples and their experience continue to be understood in a better way, and that these experiences and rights be centered when we think about state action. Durrell articulated this really well, that there is this widespread failure to understand how Indigenous rights intersect with state action. I think right now, the transition to clean energy and green energy is a great example of that worldwide. For example, a lot of the state proposed solutions for achieving net zero by 2050 come in the forms of clean power stations, carbon capture and storage facilities, new mines for transition minerals, and all of these rely on using indigenous lands and resources. In the United States, tribes could provide 10% of the nation's total energy and nearly 7% of US renewable energy capacity. And so this is enormous generative potential, but right now only 14% of households on Native American reservations lack access to electricity. These rights aren't being centered when we're thinking about this just transition and what this would look like. And specifically with the United States and many other states around the world, we see that they're holding themselves again to a less stringent standard. Here we have the process of consultation. That's not in adherence to the declaration or in the spirit of the declaration. And rights like FPIC are not incorporated at levels of government with federal agencies that are making decisions that are then impacting tribes and indigenous peoples. And so right now, when we have this significant demand for transition minerals and moving to green energy that are found on indigenous lands and using indigenous resources, this is still being pursued without consent and active partnership of indigenous peoples. And again, it will continue to not benefit these communities that are having resources taken without this active partnership. So just coming back to sort of my original point, centering these rights in all stages of development, whether it be a business centering rights or the state, is key to moving forward in a better way and working in partnership together.
Thank you, Christina. And last but not least, Dr. Gladstone.
I affirm all the other recommendations that have been shared so far. Every is important to add on top of it, and something that's important is that the states need to work very hard to listen and respect Indigenous people on equal terms. Applied throughout all centers. Increase the recognition of Native and Indigenous peoples' economic sovereignty is very important. That Indigenous people have their resources that they should control on their own terms and not exploited by others. And also recognize that Indigenous peoples do have skills in trade. They've always had historical skills over centuries prior to being colonized. They had done trade on their own before colonizers came in. So recognizing that these skills in trade do exist. and work on inclusive education, and not just bringing in Native people into Western classrooms, but bringing in Native wisdom along with those students, and recognizing and respecting that Native wisdom and seeing the value that that wisdom has, just for students, but for all students in education systems.
Well, I want to thank you all for this fascinating discussion. I've heard so many important things: access to resources, to have effective access to the courts, territorial rights, understanding of inherent rights, and as Christina said, centering those rights, listening to and respecting Indigenous peoples, truth, collaborative efforts. And what I'd like to do is wrap up, and we're going to show a video before we go, but I just wanted to share a few thoughts from a couple of Indigenous leaders in Canada who have thought very deeply about this issue of the implementation of free, prior, and informed consent. And the first is the Honorable Jody Wilson-Raybould, the first Indigenous Minister of Justice and Attorney General of Canada. And she said, look, operationalizing consent may also be thought about in consideration of the types of relations that are typically seen between governments. In such relations where governments must work together, there's a range of mechanisms that are used to ensure the authority and autonomy of all governments is respected, and that decisions are made in a way that is consistent and coherent, and does not often lead to regular or substantial disagreement. Now, the other is Dr. Wilton Littlechild, and he was here last year with the group, and he said, look, Indigenous peoples must be part of decision-making when our rights and well-being are at stake. Working with us to determine what it looks like is the smart thing to do. It will lead to fewer acrimonious decisions, fewer court battles, more timely decisions, and better outcomes for us all. And so with that, I'd like to thank you all again. I'd like to thank Ambassador Lee, and we are going to go to the video. Good night. Thank you to you all. Goodbye.